My name is Elise Gross, and I've been an attorney for over 25 years, practicing in South Florida in this area of estate planning and asset protection. In addition, I teach at one of the local universities in their paralegal department. Today, we're going to be speaking about fraudulent transfers. We'll be talking about some examples, where it fits in, whether it's a crime or not a crime, talk about some of the laws, and mostly about badges of fraudulent transfers. What do the judges look for when they're determining whether or not something is a fraudulent transfer? So what exactly is a fraudulent transfer? So just by definition, it's a transfer that somebody makes with the actual intent to hinder, delay, or defraud any creditor of the debtor. So the debtor is the one that owes the money, and the creditor is the one who theoretically is owed money. Now, generally, a person is not even a creditor until they actually have a judgment against the debtor. And now we use the term debtor for somebody who owes money, but really the term debtor is a bankruptcy term for someone who's in bankruptcy and owes, and it's the bankruptcy trustee that's seeking out recovery of assets in order to pay off the creditors. Essentially, the way this works is, did you owe somebody money, and did you then transfer assets out of your name for less than fair market value with an intent to not pay your creditor? So did you take assets that you had potentially available to pay a creditor, and did you transfer them out so that the creditor could not get paid? Now, I can tell you that there is absolutely no clear path here. There's no rhyme or reason necessarily to how the judges determine what's a fraudulent transfer. There are certain things that they look at, but in the end of the day, there's very broad discretion on the judge. It depends what judge you have, where the judge is sitting, in what jurisdiction, what day it is for the judge. Did they have a good cup of coffee or a bad cup of coffee? Did they have bad traffic on the way in? You really just have no idea sometimes how these things are going to turn out. So what might look like a very clear fraudulent transfer to someone might just be completely turned by a judge, and the judge may say, no, it's not a fraudulent transfer. The way that has to be viewed is it's the totality of the circumstances. The judge essentially likes to look back and say, try to determine what were you thinking under the circumstances, and was that justified? Was the transfer that you made out of your name of your assets justified at the time under those circumstances? They look for the motivation. They want to find a legitimate reason for the transfer. And I think in most cases, judges really aren't looking to make it a fraudulent transfer. But, they have only what they can go on, which are the facts and circumstances, and what are the optics? How do things appear? So obviously, if you're making a transfer, when you've got a situation, you want to make sure that the optics are as good as possible. You don't want to do anything that is really going to trigger a judge getting all upset and considering what you did a fraudulent transfer. Now, depending on where you are, there are going to be different rules that apply. So, it's going to change. One thing might look bad in one state and may not be a problem in another state. You've got to just see where you're at and what jurisdiction is going to apply to kind of do an evaluation of whether what you've done is a fraudulent transfer. If you're evaluating whether or not it will be a fraudulent transfer, then if you really think about it, is that really the intent right then and there? If you have to think about it, there might be some intent. So you want to try to be careful about that and who you discuss it with, because the intent is the crux of this matter. When a fraudulent transfer is determined, it's generally a civil remedy that a creditor has that a judge could then overturn whatever the transfer was and then invalidate and potentially unwind the transfer. So here's a couple of examples. So John borrows $200,000 in 2013. In 2016, he stops paying on the loan. In 2018, he gives $100,000 to his son. The note holder files suit to enforce in 2019. He already owed the money in 2018 when he transferred the $100,000 out of his name, when he gifted it to his son. So, in essence, even though the creditor had not filed suit, they were entitled to file suit. The money was owed. John clearly owed the money. So in that, it's pretty likely that that transfer would be overturned and unwound as a fraudulent transfer. Now, the way that would work is the judge would then unwind it, and then if it was bankruptcy, or even if it wasn't bankruptcy and there was a creditor, the creditor could then sue the son for the $100,000 because the son should not have received that $100,000. So if you've done it, you have to be super careful who you give your money to, because those people can be brought in as a party to this action and potentially have to give the money back. Another example, Bob has a judgment against him for $1 million. He has a building worth $500,000. He sells the building to his friend for $50,000. So he had an asset that was worth $500,000. That asset could have been seized by the creditor and sold so that at least half of the debt could have been paid off. Instead, what Bob does is he takes the asset and sells it for way less than its fair market value to someone who is not even a third party, an adverse third party, or any third party. Call it, it was a friendly sale. Therefore, in that case, chances are that the judge is also going to overturn that and say that the property has to either be put back where it was and then it's available to the creditor, or the creditor might have a remedy against the friend to seize that building. Another example, if a corporation is insolvent and can't pay its debts, and the board of directors issues dividends, that could be a huge problem. The board of directors could potentially be held liable on that for doing a fraudulent transfer because the corporation wasn't even able to pay its debts. How dare it issue dividends to its stockholders? Now, when you're in bankruptcy, if you transfer to what we call a self-settled trust, they can look back 10 years to when you transfer. So what a self-settled trust is also kind of known as an asset protection trust. If I create a trust with myself as a beneficiary, but someone else is the trustee, it's probably a corporate trustee who has broad discretion over whether or not distributions can be made to me, then assets that I have transferred into that trust are subject for 10 years to be fraudulent transfers. Now, depending on where you set up this asset protection trust, if it's domestic, meaning within the United States, or it's international outside of the United States, it could be extremely hard for anybody to actually go collect it, but they still might be considered fraudulent transfers. Question that always comes up is whether or not a fraudulent transfer is a crime. In about 18 states of the United States, it's some form of criminal act. It can be a misdemeanor, it can be a felony. In California, I believe it could actually be both, not just a misdemeanor. And it's going to depend. And again, whether it's considered a fraudulent transfer from a criminal standpoint is going to depend on, how the judge sees the circumstances, sees what you did, what was the intent under the circumstance. Now, obviously, when it's criminal, it's going to be a stricter criteria as to whether or not something is a fraudulent transfer for criminal purposes than if it was a civil action. Where it's not a criminal action, it is a civil remedy. What that means is that if I'm a creditor and I have a judgment against you, then I'm going to do my very best to collect on that judgment. So what I'm going to do is I'm going to figure out what you had. Usually I'm going to send you interrogatories to fill out. I'm going to depose you under oath, and I'm going to get all of your books and records to find out what you had so that I know what's available to pay me. If I determine during the course of that you have transferred something out of your name and transferred it for less than fair market value, then I'm going to go to the judge and I'm going to say, look, that was an asset that was available to the creditor and it's no longer available to the creditor. I want it back. And if you can prove to the judge that the transfer was made with the intent to hinder, delay, or defraud the creditor and rendered the debtor unable to pay the creditor, then the judge has the option of giving the creditor the civil remedy of a fraudulent transfer and clawing back that actual transaction. There's also, now, just quoting the Florida Constitution, you can acquire, possess, and protect your property. So the question is, if you don't have a judgment yet, could what you do be a fraudulent transfer if you're just protecting your property? And there are many questions that come up there, and there's really no right or wrong answer. Again, you've got to look at the optics of the entire situation to determine whether or not it's going to be a fraudulent transfer. And the individual who's making the transfers really doesn't have the ability to determine. They just have to think, how would somebody else view this transaction? If somebody else might view this transaction as a fraudulent transfer, then they have to make sure that they have a way to justify that transaction. There's also something called a fraudulent conversion, which is when you take an asset that is not exempt and you convert it into an exempt asset. So what are exempt assets? An exempt asset is one that under the statute or under bankruptcy law is exempt from the claims of creditors. Generally, that's going to depend on state law. So for instance, if you're in a state like Florida where we have some wonderful exemptions, your homestead is exempt. Annuities are exempt. Retirement accounts are exempt. Cash value life insurance is exempt. There's a lot of exemptions that you have here. If you take money that's in your regular bank account and you buy a homestead with it, that might still be okay. It might not be considered a fraudulent act. If you put it into your retirement, it's probably considered a fraudulent conversion because you're taking a non-exempt asset and you're making it an exempt asset. There are even rules about converting from one exempt asset to another. If you're converting from an exempt asset to another exempt asset, you're generally in a fairly safe zone. Doesn't mean anything is guaranteed, but you're generally in a fairly safe zone. But before you would actually make any transfers, it's probably a good idea just, consult your attorney, see what they think, see what the optics are going to look like. Again, it doesn't mean that there's a right or wrong answer. Certain things are pretty obvious, but most of the times it's really going to depend on what the actual intent was. What was the end result? Did it leave you with nothing to pay a creditor? Or maybe it left you with exempt assets, which technically the creditor can't get, but you haven't transferred everything out of your name. So you have to really look at what is the big picture before you make any sort of transfers. And fraudulent transfer law is based on, at least in most states, about 43 states, are the Uniform Fraudulent Transfer Act. And some form of fraudulent transfer laws have been around for probably about 100 years. But the Uniform Fraudulent Transfer Act is the one that's prominent in most states, including DC and the U.S. Virgin Islands. And the standard of proof there is that you have to show that there was intent to do a fraudulent transfer, to hinder, delay, or creditor, and not pay them so that the creditor goes without payment and you got asset. Depending on what jurisdiction you're in is what the standard of proof is. So most places, it is not the highest standard of proof. It's the preponderance of evidence. With that said, if you do anything on an international level, meaning if you set up, whether it's a trust or some sort of company in another jurisdiction, there you might be able to have a beyond a reasonable doubt standard. So it's going to depend where your assets are and what law is going to apply as to whether or not the creditor has a higher standard to prove or a lower standard. Obviously, the higher the standard, the better it is for you, because the creditor has to show this in order to get anything unwound. Now, the general rule, and under the UFTA, is there's a 4-year statute of limitations on the transfers, and that's the majority of transfers, which means if you transferred something in 2010, even if you had a creditor at that time in 2018, it's too late for the creditor, when they finally get their judgment, to claim a fraudulent transfer. So there's an unfortunate situation in America where cases take a very long time to actually finish up and go to a judgment. That's bad because you're paying the attorney's fees, and it's bad because you have to deal with, the litigation and the emotions of litigation and all the work that goes into it. But on the other hand, from a fraudulent transfer standpoint, if it took that long for the judgment to be issued, then potentially transfers that were made at the beginning of the case won't even be open to a fraudulent transfer claim. So again, there are certain things you can look to the future on. You don't know how long a case is going to take, but chances are if it takes 4 years or more, then any transfers you made at the beginning of the case won't even be open to a fraudulent transfer claim. The creditor may try anyway, but if it's over the 4 years and the claim has been made, then the statute of limitations will probably have run. Now, one of the things is in the UFTA, the creditor doesn't actually have to prove intent. And that's really important, because if the creditor doesn't have to prove intent, then it makes the claim a little bit easier for the creditor. And again, we're going to talk about the different badges, the things that the court looks at. We're going to talk about 9 of them. There are more, but we're going to talk about the 9 main ones. And even though I think there's probably about 15 or 18 in total, some of the ones we're going to talk about really probably count as more than one. So what the judges look like at are these, what they call badges, and it actually says that in the UFTA. So you want to look at this when you're, review them if you're making a transfer, so it'll help you to kind of determine whether or not what you're doing might look like a fraudulent transfer. So the first one is if you transfer something to an insider. Who is an insider? Well, an insider is somebody that is either related to you, somebody that's under your control. It could not even be a human being. It could be a business. Did you, create entities and then transfer your assets to them without getting anything in return? Now, you may say, okay, I've created an LLC, a limited liability company. I've transferred assets into the limited liability company. Isn't it an obvious fraudulent transfer? If I had a creditor, I transfer assets into it. Well, not necessarily, because in return for that transfer into the LLC, you're getting the membership interest in return for it. So you are actually getting something for value. So that's not an automatic fraudulent transfer. And you want to, you definitely want to look at the timing. Would it be considered a fraudulent transfer when the creditor wasn't pursuing their claim? It's, again, timing is going to be very important. You want to look at the entire picture. Did the debtor retain any possession or control of the property transferred after the actual transfer that's being tagged as fraudulent by a creditor? Okay, so let's use that LLC as an example. Did the debtor retain control of it? Was the debtor a manager? Did the debtor continue use of it? So if the debtor is the manager of the LLC, then you can potentially say that the creditor is still in control, but the creditor doesn't have any, he hasn't really transferred the asset away if he's still in control of the asset. Sorry, a little technical difficulty there. In contrast to that, if you put your home in a trust and you continue to live in it rent-free, then the judge is going to say, you know, you've given it away, but you're retaining the benefit from it. So therefore, it's an asset that you control. Therefore, it's an asset that the creditor could then take away from you potentially, because you still completely control it and it is still yours. Did you hide what you were doing? One thing you need to know about doing anything in the terms of asset protection is that hiding is not what you're looking to do. Privacy is great. That's fine if you want to do something that's private. But did you do something that you intended to hide from someone? Because if you're hiding something, then that's going to be looked at more than likely as fraud. So look at the full picture. Did you make an attempt to hide what you're doing? Because really what you want to do is think about it as, if everything were out in the open, would what I have done be considered a fraudulent transfer? If I'm trying to hide something, chances are what I'm trying to hide is not a good thing, and a judge is not going to be pleased with that. The timing. Badge number 4 is all about the timing. Did you get sued before you made the transfer? Was there a threat of the suit before you made the transfer? Was there a judgment? Those are different levels that we're talking about. So if it's just a question of there's a threat, we'll call that level, I'm going to call that level 1. Filing of suit, call it level 2. And actual judgment would be level 3. Once there's a judgment issued against you, then it's pretty clear on the face if you transfer an asset for less than fair market value, especially if it's to an insider, that it's going to be a fraudulent transfer. That's really not what we're talking about today, because those things they're not cut and dry, but there's much more obvious in those. What we're talking about are things like if you have an accident and you had an accident, even if you don't think it was your fault, but you had an accident and somebody may or may not have been hurt. And then you start transferring assets. No one's made any claim against you. Nobody's made any threat against you, but you know you've had the accident and you make some transfers for less than fair market value. At that time, did you have a creditor? Well, truth is you really don't know. Then if you take it up a notch and say, well, okay, I got the letter from the insurance company or from a lawyer saying that there's a potential claim, the notification letter. Okay, well, now it's up a notch. Now there's a threat. Then once they start suing you, well, obviously you know that they're looking for money. So they are a creditor a potential creditor at that point. You're not being proactive. So that might be more of a case for a fraudulent transfer. And then obviously that final step of the judgment, we don't need to discuss that further because that's a fairly obvious situation. So, if you have this situation, you have to look at what the timing is going to be, whether or not you think whatever is going to transpire, when are they going to file the lawsuit, how quickly do you think they're going to get a judgment, how long would that be? So if you think it's going to be a very quick situation, then probably whatever you're going to do has a good chance of being clawed back as a fraudulent transfer. Now I want to point one thing out to you. Just because something has been transferred out and is considered possibly a fraudulent transfer doesn't mean it's a definite don't do it. You can consider doing it as long as you understand what the ramifications might be. That it may require you to later defend it and pay attorney's fees, and it may require you to pay it back. So if you know that that's a possibility, then you can make an educated decision whether it's worth it for you to risk it to make the transfer. But you've got to make an educated decision if you're thinking about it. In addition, you want to have some sort of story, so to speak. What are you telling the judge? What was your reason for the transfer? Because you can't walk in there and say, yeah, I just figured that I'll just transfer it, hope the guy doesn't get a judgment against me, and then hope you don't decide it was a fraudulent transfer. Obviously, that's not going to work. Was it some sort of estate planning that you were doing? Was it a reorganization in your business? Was it, to help your children? What was your reasoning? Did you think that the market was going to tank, so you quickly sold out? What was your reasoning for making this transfer? You need the story. If you transfer substantially all of your assets, then you are potentially creating a situation of insolvency where you can't pay your debts. If you do that, so you transfer everything at one time, then that is going to be looked at as an intent to not pay your creditor. Because you knew that you had a creditor, you transferred your assets out, what's your justification for that? If, on the other hand, you kind of have a plan over time and you don't do everything at one time, you try to, transfer things for some value, then you have a different story to tell. Because technically, it's really all about the story that you can tell. Running away, there's really not much to say about that. If you run away with the money, then the judge is not to look favorably upon you. And the judge would likely just throw the book at you anyway, just because they're not happy. Remember, the judges are human beings. They have emotions. And if they don't like what you're saying or how you're behaving or how you behaved, chances are they can decide against you just on that basis, because they'll probably be able to find enough facts to support their ruling when they're talking about a fraudulent transfer claim. If you remove or conceal assets, if you remove them out of the country and you're not upfront and honest about it, then, it's possible that a judge is going to look unfavorably upon it. Again, you always want to make sure that whatever you do, you're willing to sit in front of a judge and explain it to the judge. You may not even be able to move your assets if you have creditors, depending on what you're doing with them. They may not be accepted. For instance, if you set up a trust, they may not accept the assets. The trustee may not accept the assets if you have an existing creditor. You have to, talk to the trustee and determine. But remember, everything you do, you have to be able to defend, because it's all going to come out in the wash. I said privacy is good. There's no problem with privacy. Hiding is not going to work. Here's an interesting one. Consideration. What was received in exchange for whatever it is you transferred? So whenever you're talking about whether something was given away as a gift versus sold for fair market value, you have to look at what was received in return for what you've given. If I just give my child $100,000, that's a clear gift. Therefore, that's a transfer. It went from me to my child. Child didn't give anything back. If I had a creditor, chances are they'll say that's a fraudulent transfer, and it's probably going to be pretty clear. What can happen is if I instead have an asset that I sell and maybe get a little less than fair market value for, if I can defend that transfer as saying, well, maybe it wasn't exactly fair market value at the time, but it was pretty close, then chances are that one is going to be overlooked and it won't be a fraudulent transfer, or at least not based on that particular badge. Trusts, depending on the type of trust you have, is whether or not they will work as an asset protection tool and will avoid fraudulent transfers. But for the most part, as I told you before, if you're transferring it into a trust that's for your own benefit, a self-settled trust, and their bankruptcy court looks back 10 years. And if you're transferring it into trust for your children, even if it's an irrevocable trust, chances are there's going to be a look back on it. And where was your value received in exchange? Probably nothing. Therefore, there's a possibility that they're going to bring the trust into the action and consider that a fraudulent transfer. If you become insolvent as a result of whatever it is you transfer, or you were already insolvent at the time, unable to pay your bills as they came due, judges do not look well upon that. That's one of the clearest badges of fraudulent transfer. Not much discussion has to happen after that. So you have to be very careful if you're making the transfer to evaluate what does that mean. Will you be able to pay your debts? Now, if you're transferring and you are still earning a good salary, which allows you to pay your debts, then you're not insolvent. So that may have a factor into this situation. But if you can't continue to pay those debts, if you're rendered insolvent by the transfer that you made, then it's going to look bad and be considered a fraudulent transfer. So what have we learned? I think the underlying thing that we learned is judges are human beings, that fact circumstances are critical in the scheme of things. Timing is critical. There's nothing that's black and white. When you make the transfer and what value you receive and whom you make the transfer to are going to be critical elements in the big picture. And that's what fraudulent transfers are all about. What's the big picture? When did you make the transfer? How much did you receive for it? Who did you make the transfer to? And what were the circumstances? And then they look at what was the actual intent behind the transfer. Did you intend to do something that would render your creditor unable to get paid either all or a part of whatever they were owed? In determining fraudulent transfers, we always want to look at who the actual creditor is. Is it the bankruptcy court? Standards are higher. Was it just a regular creditor, just somebody, I didn't pay the credit card, I didn't pay the mortgage? Or is it a super creditor? Was it any of the IRS, SEC, the FTC, the DEA, the FBI, anything with a 3-letter essentially is going to be a super creditor, and they have broader powers. And they can pursue you even in an international jurisdiction. They have broader powers because if you're doing it on an international level, obviously, hopefully you're dealing with very reputable trustees or, corporate managers or LLC managers, and they may be potentially bullied by those 3 letters, and it's not necessarily going to be a slam dunk situation. So you have to be very careful. And then, of course, there's the issue of a divorce. Does a spouse become a super creditor? And in a lot of situations, the spouse does sit sort of like a super creditor because family law attorneys are also very open to emotion, and family law attorneys do things that we just can't predict. Therefore, depending on the circumstances, depending on what the judge is seeing when the spouses present themselves, is really whether or not a fraudulent transfer is going to be upheld when you're talking about transfers that were made during marriage. Because they may be made during marriage in order to impede the other spouse from getting those assets. And if it's a messy divorce, it's all going to come out in the wash. Whether there's forensic accounting or no forensic accounting, it's probably going to come out, and you need to make sure that you're contemplating that when you make a transfer, because your spouse potentially could get that back as part of the divorce. Even if you can't get the asset back, that amount could be imputed to you and you'll never see it, but the spouse then gets a larger share of your assets because you transferred that asset out. And lastly on that, if you've got a lawyer pursuing you, good luck, because they're probably going to pursue you to the end of time. And I'm going to put them, they're not a super creditor in the fact that they have the same rights that, the IRS might have. However, they have the motivation, determination, and the means to pursue you. So chances are they're gonna continue going and trying to force you at some point to give up assets. And if you don't have them, they're probably going to pursue that fraudulent transfer claim more so than another creditor might. When you're talking about bankruptcy, which is really a good part of the fraudulent transfer law, you have to look at who received an asset. And in bankruptcy, the bankruptcy trustee is in charge of finding all the assets of the debtor to potentially pay back a creditor. So a bankruptcy trustee can look back on transfers for a year if it's an insider, and for a non-insider, a year for an insider, and 90 days if it's not an insider. So again, we talked earlier about the insider might be a family member, close friend, an employee, someone with whom you have a close relationship rather than a third party. But you don't even realize that if you have a creditor and you pay debt to somebody else, that person might have, even though they were legitimately being paid, because they received money and another creditor did not, that creditor might have to give back that money. As a parallel situation, we have this in the probate court. When somebody dies and go through probate and we have to pay off creditors, we always tell the client not to pay anybody, because in order to be paid in probate, if it's not an ongoing administrative expense, a creditor has to file a claim. And if instead I say, oh, you know what, I really think this person should be paid, I'm going to pay them. Well, if other claimants come forward and there's not enough money to pay the other claimants, they can go back and get the money that you paid the other creditor, because it's a preference. So you have to be very careful who you're paying and when you're paying, because these things can be looked back upon. The judge is going to determine everything. It's all based on the optics. What are the remedies? If they get the fraudulent transfer remedy, then the creditor can potentially unwind the original transfer, or they can go after other assets, which theoretically they could have done anyway. But, here the creditor can go after whatever they want, including the asset that's been transferred. Anyone who has any questions on today's webinar should email in to info@assetprotectionattorneys.com, and we'll make sure to get to you. And again, if you're not already receiving our weekly newsletter, please email us and we'll be happy to get you on the newsletter. It's got some very good content and it's an email, so we're not mailing it out to you. It's very simple. And if you're interested in any copies of the asset protection books that our managing partner has written, we'd be very happy to send them to you. Just send us an email. And if you're interested in any speaking engagements or a complimentary preliminary consultation, we're always happy to help. Thank you for joining us today. Next month's webinar is on March 21st. It's on estate administration, going into different types of probate administration and touching on some non-probate administration. We'd be happy to have you join us. Have a great rest of the day.